Good morning. My name is Dan Bress, and on behalf of the Ninth Circuit Education Committee, it's my privilege to introduce the two distinguished speakers this morning for our annual Supreme Court review. Amy Howe is a lawyer and journalist and the co-founder of SCOTUS Blog, a website devoted to coverage of the Supreme Court of the United States. If you're someone who has refreshed this website several hundred times in the last several weeks, you're at the right conference. Before turning to full-time journalism, Amy was a lawyer who practiced and argued regularly at the Supreme Court. She's also taught Supreme Court litigation at Stanford Law School and Harvard Law School. Jeff Fisher is a professor of law at Stanford Law School, and he's co-director of the Stanford Supreme Court Litigation Clinic. Jeff has written broadly in the areas of constitutional law, criminal law, and the federal courts. He's a former law clerk to Justice Stevens, and he's argued 48 cases in the United States Supreme Court. Jeff and Amy are going to speak for roughly 50 minutes, and will then answer questions for about 15 to 20 minutes. There are blank note cards on your tables with pens, and during the talk, if you have questions, you can write them down and raise your hand, and a staff member will pick up the cards. So without further ado, please join me in welcoming Amy Howe and Jeff Fisher.
Feels just like Oprah.
I know.
But you're not all getting a car. I apologize.
This is the fireside chat without the fire, which we don't
outside,
need today.
yeah.
That's outside. Well, Judge Bress, thank you so very, very much for this invitation. It's wonderful to be here with Amy. We've known each other the better part of 20 years and taught together and interacted in various ways. So we're hoping that we can provide some value and interesting points for you over the next hour or so. I can't resist saying, though, that I appreciate the minimal biography. I always like a short introduction, but I will also add that before I clerked for Justice Stevens, I clerked on the Ninth Circuit. And so my post-law school career began on this court, clerking in downtown Los Angeles, and seeing a vantage point of just the incredibly vibrant bench that the Ninth Circuit had to offer. And my whole professional career has been based in the Ninth Circuit, first in Seattle and now in California. So it's a particular privilege to be able to be part of this conference and see old friends and new faces and so many people who I respect and haven't even had a chance to meet until this conference. So thank you so much for the invitation. So Amy and I thought we would go in roughly two steps here. First, we would talk a little bit about just some general themes that we saw come out of this term, and maybe even more generally in the Roberts Court right now, and then do our best to hit some of the high notes from the court's docket this term, and maybe kick around some ideas about what we think we might draw from some of the court's bigger decisions that you as judges and you as lawyers will be dealing with immediately and perhaps for years to come. So I'll just start, and we'll go back and forth here a little bit on the thematic level. It always occurs to me that when you do a talk like this, typically what it consists of, and for the main part will consist of today, is these high-profile cases and big decisions on the court's merits docket. But before we just jump into that, I thought I would just pull the lens back even further and just ask ourselves, like, what is going on more generally at the court right now? And one of the things I think has been going on for years, and the trend continues, is the incredible shrinking merits docket. Decades ago, the court was hearing 150 cases a year. When I clerked, it was about at 80. And now the court, the last couple of years, is below 60. So the court's hearing fewer and fewer cases. And this is just kind of an inchoate idea that I'm still playing with, but I almost feel like as I participate a little bit in the court's work and more generally follow it, that the nature of the court's work and its relationship to the judicial system and our democracy is meaningfully changing, so that the merits work the court does is certainly not the only important thing the court is doing, and sometimes it's maybe not even the most important thing the court is doing. What we sometimes call the shadow docket, but when I clerked, it's just called the emergency applications docket, has become more and more prominent, so that when I was at the court in the spring for a couple of cases that I argued, just talking to people in the clerk's office and the like, it was like we have fewer cases on our docket than ever before, and we're busier than ever. They just felt like the flood of important political and policy issues coming to it from the shadow docket in particular, I think is really having a real effect on the court's work and the interaction between it and the other branches and the lower courts. So just to flesh this out a tiny bit more, why would the court be hearing fewer and fewer cases? Well, I think one thing is that Congress is passing fewer and fewer statutes. So maybe there's less work to do by way of solving circuit splits or figuring out new laws. I mean, there's a few laws here and there. The Fair Sentencing Act I was talking about this morning with somebody. Few things here and there, but there's not the big momentous legislation that tends to kick cases up to the court. Also, maybe they're just being more selective because they're spending more time on the cases they actually handle. Oral arguments, many of you may know, have gone from the very, very strict 1-hour time limit that Chief Justice Rehnquist imposed to now a two-stage process where there's a free-for-all and then one-by-one justice questioning so that arguments themselves are lasting maybe more like 2 hours than 1 these days. Amy can probably tell you more about this from being in the courtroom.
Yes, but I'm not arguing them like you are.
Exactly.
So I'm just sitting there writing things down.
Yeah, I used to say the moots are supposed to be longer than the argument. It's turning out the other way around these days. And also they're writing more separate opinions than ever. And longer opinions than ever. So, and then the last thing I would say, and this is I think a little noticed feature of the most recent change in membership where Justice Ginsburg passed away and Justice Barrett came onto the court and then Justice Jackson came onto the court. But where in many situations you have a 6-3 division on the court, it takes 4 votes to grant cert. So I think the cert voting has changed on the court so that the Democratic appointees no longer have 4 votes to put a case on the docket, and maybe that's one aspect of how the court's docket has been reduced. So just a few different thoughts. And then one last thought about the emergency docket, and I'm super curious to hear Amy's perspective on this, is covering it. I know my journalist friends find the emergency docket really challenging. But this seems to be very much a topic of internal conversation, and actually one of these areas where the bench and bar are really interacting with the court, and the academia as well. Late in the term, Justice Kavanaugh wrote a separate opinion in one of these stay cases where he said, look, I recognize we're doing more and more of these early decisions on big ticket issues where they're coming to us with records that are woefully underdeveloped and often, we have to decide them within 48 hours or something, or at least decide what to do, even if it's just put the case on our docket. But his perspective seemed to be, look, that's just going to be the way it is. Maybe we can curtail this flood of emergency applications by cutting back on some of the rules surrounding nationwide injunctions and standing and the like, and maybe we'll talk about that a little bit today. But we're going to have more and more of these cases where we have to make an early decision and an early assessment of the merits in ways that really forces the court into our sort of, into cases themselves and into kind of our political interrelationship between the branches in ways that I think feel different and new to me. So I think I just wanted to let that out there before we went into the docket. I don't know, Amy, if you have reactions about that or other things.
I do, actually. Shockingly, I have thoughts about the shadow docket. I mean, this is something, and Jeff mentioned that there was a little bit of a dialogue going on. When the shadow docket really got to be active, there was a fair amount of criticism from the bar and from the press of the court's shadow docket practice, that they were issuing these decisions that, with no opinions or very, very brief opinions, decided some pretty big issues, I don't have to tell you all, put, the construction of the border wall on hold, things like that, indefinitely. And so the Supreme Court started to adopt a practice of at least occasionally taking up and hearing argument in these cases on a relatively fast track. And people in the press and the bar started to point to these as an example of, you have options other than just to sort of throw up your hands and say, these are happening so quickly that we can't do anything else. The opinion by Justice Kavanaugh talking about how quickly they have to decide, one of the things before I knew exactly what you were going to say on this topic was to notice that the sort of the concept of what the shadow docket covers has changed pretty dramatically over the past few years as well. When I started practicing before the court and covering the court, the capital cases were the quintessential shadow docket cases, and sometimes they would come in, and the court would have to rule on them even in the same day. They'd come in the morning, and the execution would be scheduled at night, and the justices would have to act very quickly. But two of the cases that came up to the court on the shadow docket this term, it wasn't that they had to act in 48 hours. They took, in both the Clean Air Act case, Ohio versus EPA, and then the pair of cases, Moyle versus US and Idaho versus US, the Idaho abortion cases, which we're not going to go into a lot of detail about because they're coming back to you all in the Ninth Circuit. But in both of those cases, Idaho and Ohio came to the Supreme Court seeking a stay, and it took the justices about 2 months before they even acted on the stay application. Now, this is not sort of this was not exactly fast tracking.
Yeah.
And I do think it's going to be very interesting given, and again, we're not going to go into the details, given the court's disposition of the EMTALA case, the concerns about not having had all of the information when they decided to take up the case to see, whether the pendulum swings back in the other direction on these shadow docket cases.
For sure.
So I'm going to talk a little bit about some of the dynamics on the court. We talk about the Roberts Court, that he is, as you know, really just the first among equals. He only gets one vote. And so in the past few terms, there have been times where his conservative colleagues have effectively seemed to say to him, we're going on without you. Like, if you want to come along for the ride, in our shift to the right, that's fine. We're glad to have you, but we're going anyway. And so in the Dobbs decision, for example, the Chief Justice would have upheld the Mississippi law at issue in that case, but he would have done it without formally overruling Roe. In the Texas SB 8 case, he would have allowed all of the challenges to SB 8 to go forward. And so Justice Alito in Dobbs wrote the decision, the sort of famously leaked decision, instead of the Chief Justice. But this past term, he was really, to borrow the basketball metaphor, the captain, the point guard, whatever you want to say, like he was driving this ship this term. If you look at the statistics, 96% of the time he was in the majority. He was the justice most likely to be in the majority. And in the divided cases, the 6-3, 5-4, he was again the justice who was most likely to be in the majority in those cases 93% of the time. And you often hear him discussed in the press as an institutionalist, someone who wants to build a public consensus. But in some of these cases where he was driving the ship, like the presidential immunity case or the Colorado ballot disqualification case, which we're going to talk about, he was the one who was willing to go ahead, even if it meant leaving some of his colleagues behind and not having the kind of public consensus, full consensus on the court that he wanted. And so another sort of through line this term was one of the colleagues that he sort of left behind in those cases, which was Justice Barrett, who finished her 4th term on the court this year. And she's always been a very interesting and precise questioner. She's always been one of the best writers on the court, clearly. But there were a lot of articles at the end of the term this year about Justice Barrett carving her own path, finding her own voice. And I think that is true and noteworthy, but I think only to a point. She had some interesting dissents in the Fisher case, which Jeff is going to talk about. In the Ohio versus EPA case, she joined the court's liberals on that ground, and she had some interesting separate concurring opinions on her view of the role of history when you're interpreting the Constitution. But she was in the majority in all 3 of the administrative law cases. She wrote one of them. And even to the extent that she is carving her own path, to the extent that would mean sort of changing the court's path, we haven't seen that yet. Because as Jeff said, talking about cert, when you're talking about decisions on the merits, you need 5 votes. So even if she joins with the court's liberals, that only gets you to 4. So there may come a point at which Justice Barrett and sort of her views may put the brakes on the court's shift to the right, but I don't think we've seen that yet.
Yeah, I would echo that. I think just a couple thoughts about justices themselves, and I think Justice Barrett is among the most fascinating stories to watch this term. I was lucky enough, actually, all the way back to my clerkship. She was a clerk for Justice Scalia the same term that I clerked, and so I've sort of known her and watched her work for years. And I think it's striking that in some ways she's the most lawyerly of all the justices on the court right now. She's the deepest in the record, the deepest into the particular sub-A Romanet 2, Clause 3 of the statute and how it fits together with Clause 5. And so as the court takes up these cases and has so many options to do something, big and programmatic versus, small and technical, she seems to be pulling the court in some of these cases maybe towards a more narrow, fact-bound decision-making. But we'll see. I think you're right, whether the court is listening in some of those cases, and as the court continues to change personnel-wise, whether that'll ascend or not.
I mean, sometimes we sort of talk about Justice Thomas, who would write these separate opinions that, he was sort of solo dissenting or solo concurring for years, and then, would gradually attract support. And, maybe she's sort of putting that flag in the sand.
Could be, yeah.
I think it's just that one of these time will tell.
Yeah, and I think the other justice that's so interesting is Justice Jackson this term, who, as the junior justice on the court, wrote the most separate opinions. I think it was 25 opinions she wrote this term. And I think the chief and Justice Kagan, for example, were in single digits. So a huge contrast where I think she's also looking to make her own imprint in various ways. Even breaking from some of her colleagues, which was she shares close ideological perspectives, but nevertheless breaking off on her own to speak for herself in various ways. So I think that's another thing to watch as the years start to unfold.
Right. So another sort of through line this term was the Supreme Court overturning the courts of appeals for overstepping their judicial roles in the Supreme Court's opinion. And so we saw this on both ends of the ideological spectrum, really. On the one hand, there was the Fifth Circuit in the Mifepristone case and Murphy versus Missouri, which is this social media jawboning case. And in both of those cases, the Supreme Court held that the challengers lacked standing to sue, when the Fifth Circuit had said both that there was standing and then ruled for the challengers. And Justice Barrett really sort of called out the Fifth Circuit in the Murphy case, for which she wrote the majority opinion, talking about how they approached standing at a high level of generality and glossed over complexities of the evidence. Justice Kavanaugh wrote for the court in the Mifepristone case. Wasn't quite on the same level in terms of the language, but he too said that the federal courts are the wrong forum to address the challengers' concerns about Mifepristone and the FDA's actions, that you should take this to the political forums. And then on the other end of the spectrum, we had the Ninth Circuit's decision in the Grants Pass case, the challenge to an Idaho City's ban on public camping, which, given the definition of camping in the ordinances, prohibited people who were unhoused from using blankets, pillows, or cardboard to protect themselves from the elements. And the Supreme Court upheld the ordinances. It rejected the argument that this was somehow a violation of the Eighth Amendment's ban on cruel and unusual punishment. And Justice Gorsuch, in his opinion for the majority, said, yes, homelessness is a complex problem, but the Eighth Amendment doesn't task federal judges with resolving this.
I think that's one of the fascinating themes that I'm watching at the court, is just the court's conception of the judicial role, right? So I think those are examples, and maybe you could put Dobbs in this category too, and maybe we'll talk about others today, where they're like, don't bring this to us. Like, we don't think this is fit for judicial resolution, either because there are standing problems with the plaintiffs who are trying to bring it, or because in the Grants Pass case, for example, or in Dobbs, like, this is just not a matter to which we think the Constitution speaks with any sufficient clarity that we as judges can sort out.
Right.
On the other hand, though...
One more thing. I mean, I think sort of in the press room at the Supreme Court, sometimes we get a little bit cynical. Sometimes I think sort of we talked about lurking in the Mifepristone case and the EMTALA case, for example, another sort of perhaps less highfalutin doctrine, which is the kick the can down the road doctrine. Sort of let's avoid ruling on abortion until after the election, or perhaps, depending on the outcome of the election, indefinitely.
Could be.
Yeah.
Yeah, and also you could also probably add to that, like, there are some other areas of constitutional law, like the Second Amendment and like various attacks on affirmative action and the like, where the court isn't shy to sort of get into hotly politically disputed policy issues. But I think in some ways they are trying to keep some stuff off their docket. But on the other hand, when it's on their docket, I think another theme is the court is exerting more power and centralizing more judicial power than ever before. And we'll talk about that on the demise of Chevron, for example, vis-a-vis the administrative state, and vis-a-vis Congress in various ways, I think, too, when the court says we're going to take a strictly textualist approach and not look to purpose and those sorts of things. I think that's one way of sort of saying, we are kind of taking this into our own hands. And I'd take that one step further. Again, back in the day when I was a clerk, it felt notably different in the courtroom when the court had a constitutional case versus a statutory case. Because lurking in the background of every statutory case was, well, if the court does something Congress doesn't like, they'll probably just step in and change it. And I don't think the court has that feeling anymore. The public has that feeling anymore. I mean, a dramatic example my clinic handled a few years ago, the Bostock case about whether Title VII extends to discrimination based on sexual orientation. And then that's just a statutory case. If the Congress didn't like what the court did, theoretically it could change it. But nobody thought that could ever happen, right? It felt almost like the weight of a constitutional case. And more the statutory work the court does feels like the last word, at least for the moment. And that feels like a shift to me, too.
Right. I mean, Congress is so divided. Like, I always think when something like this comes up and you're at the oral argument and one of the justices suggests that Congress can change the law if it's so desired. And there was a moment, now I'm going back to the Obama administration, and Don Verrilli, who was the Solicitor General at the time, got a question like that, and he just kind of looked at the justices and said, "This Congress?" And so, that's what's going on with so many of these statutory, but Congress is just at a standstill on so many of these hot button issues.
Yeah. I mean, it's like, it reminds me of the Donald Rumsfeld quote of, you don't go with the war with the army you have, it's with the army you want, you go to the war with the army you have. And it's kind of like, does the court decide against the Congress it wants or the Congress it has? There's like I think a lot of the court's methodological choices have to do with trying to decide whether you take a practical reality right now view of where Congress is, or you try to do things that are going to spur Congress to do better in the future. And your choice as to which of those things which of those lenses you want to decide cases through, I feel like sorts the justices in various ways. Anyhow. Well, we've talked a long time, and we haven't yet mentioned Donald Trump and his cases, so maybe we need to do that.
We'll move on to what we call the Trump docket. And it's not often you have sort of a section of the docket that is devoted to a presidential candidate, but this is 2024, so here we are. And it turned out pretty well for him. So Jeff is going to take the third case in the Trump docket trifecta, but I'm going to start with the first two. Trump, and I'm going to go at them chronologically, just for the sake of having to choose one. Trump versus Anderson, which is the Colorado ballot case. So Section 3 of the 14th Amendment says that if you cannot run for public office if you engaged in insurrection or rebellion against the federal government, although there is an exception if Congress can overcome this and give you amnesty by a 2/3 vote. So this was enacted in the wake of the Civil War to keep people who'd held office, then served in the Confederacy, from holding federal or state office again. And then it fell into disuse for a long time until after January 6th, when there was renewed interest in it. And interest really was sort of peaked just around this time last year when two conservative law professors wrote an article or released a draft of their article in which they argued that the former president could be disqualified under Section 3 of the 14th Amendment from seeking office. So a couple of state courts in Michigan and Minnesota said, no, we're not going to keep him off the primary ballot. But then in December of last year, the Colorado Supreme Court ruled that Trump was ineligible under Section 3 to appear on the ballot. So the court agreed to take up the case, and they fast-tracked it. They granted review, they heard argument a month later, and then they issued their decision 1 month after that. And they issued an unsigned opinion in which everybody agreed that states can't disqualify presidential candidates under Section 3. So everyone agreed on that. A couple of sort of rationales. One, there's a sort of a recurring theme, the idea of when you're interpreting the Constitution, you look at history and tradition. And the court said there is no history of states enforcing Section 3 against candidates for federal office in the years after the 14th Amendment was ratified. although they did enforce it against candidates for state office. And then they said that as a practical matter, you could get this chaotic state-by-state patchwork if candidates could be on the ballot in one place but disqualified in another. And then the sort of majority parted ways from 4 of the justices and addressed sort of how this disqualification would work. And they said that this fell to Congress. Only Congress, through specific legislation under Section 5 of the 14th Amendment, could disqualify federal candidates under Section 3. So Justice Barrett did not go along with this. She said, I agree with the part about the states, but there's no need to get into this question about how to enforce Section 3 at this point. And then she sort of took the kind of unusual step of chiding the liberal justices who had their own separate opinion for their tone in their separate opinion. She said there is no reason to amplify disagreement with stridency. This is not the time to do it. We should all be sort of pulling together and present a unified front at this point. And then the liberal justices filed their own concurring opinion. They agreed about the idea that we don't want this chaotic state-by-state patchwork, but they too said that states should not be able to disqualify presidential candidates. So that was all happening sort of February and March of this year. And then at the same time, the Supreme Court is getting ready to field a request to weigh in on presidential immunity. So that's Trump versus United States, again, not to be confused with Trump versus Anderson. And this was a case that came to the Supreme Court out of the District of Columbia and Jack Smith's efforts to prosecute the former president for his alleged efforts to overturn the results of the 2020 election. So the charges in that case were filed in August of 2023. The former president argued that because he was president at the time, he cannot now be prosecuted. He was immune. The lower courts, both the district judge and the DC Circuit, rejected that argument. So the former president came to the Supreme Court, which agreed to take up the case, but not quite on the same fast track that it had decided the Colorado ballot case. There was 2 months between the decision to grant review and the oral argument, and then another 2 months between the oral argument and the decision. And this time the court was divided 6-3. Chief Justice John Roberts wrote for the majority, setting out a pretty broad view of presidential immunity for former presidents. Yeah, he said, first of all, presidents have absolute immunity for acts relating to their core constitutional powers, things like pardons and appointing ambassadors, but that's not what's going on in this case. So what about their other official acts? And he said, we're going to establish a presumption of immunity for those official acts. And he said, we really don't want presidents, and I think this goes to a little bit to analogous to Jeff's point about Congress and the Congress they want versus the Congress that they wish they had, sort of worrying about this, his view of the majority's view about the stakes here. Mm-hmm. And what the majority was worried about was the idea that a former president, while he was in office, would be sort of chilled, have his decision-making affected by the concern that he would be prosecuted after he left office, and the idea that you could create this sort of vicious cycle in which presidents would prosecute their predecessors. You prosecuted my Democratic predecessor, so now I'm going to prosecute you, and we just have this vicious cycle. They sketched a pretty broad view, again, of how this was going to apply, this presumption. And they said, to the official acts within the outer perimeter of his official responsibility. And that presumption is going to apply unless the government can show that there's no danger that prosecuting the president is going to intrude on the functions of the executive branch. And then they looked at some of the conduct in the indictment. They said, to the extent that he's being prosecuted for his discussions with DOJ, that's textbook executive authority. He's absolutely immune for that. To the extent that the prosecution is focusing on his conversations with Mike Pence about rejecting the electoral votes, normally that is conversations between the president and the vice president would be immune, but to the extent that Pence might have been acting as the president of the Senate, which is not an executive branch function, this is something that the district judge is going to have to work out. And so really the upshot of this case is that It's all going to go back to the district court, who's going to have to make a lot of findings about what was or was not an official act. And another sort of final important point in the majority's decision was the majority held that evidence of official acts can't be used against the former president, even when you're prosecuting him for purely private acts. And so that is where Justice Barrett, again, sort of stepped back and parted ways with the majority. She would have held that the evidence of official acts can be used against a former president for his private acts. Talking again about sort of the liberals in their dissents took a different view of sort of what the stakes were than the majority. The majority was worried about the effect on the president while he was in office. The liberals were worried about what the effect would be on the president while he was in office if he did have immunity. And so Justice Sonia Sotomayor, in her dissent, talked about the majority having created a law-free zone and a king above the law. So this case, the Jack Smith case, is going to go back. There's going to be, I think, a fair amount of fact-finding. The former president, in this case, to a certain extent, won even before the court issued its decision because of the delay. This case was scheduled to start a trial on March 4th, but that was put on hold once the Supreme Court agreed to take up the immunity question. And so I think that the likelihood that this case is going to go to trial before the November election is pretty much zero. The New York hush money payments case could also be affected by this ruling. He was supposed to be sentenced on July 11th in this case, but he is arguing that there was evidence of his official acts used against him to secure these convictions, and so that conviction should be overturned. And then Justice Thomas, in a separate opinion, questioned the constitutionality of Jack Smith's appointment as special counsel. Judge Aileen Cannon, in the Florida Documents case, dismissed the charges against the former president this month based on that argument, the idea that Jack Smith was not appointed consistent with the Constitution. So a lot going on in those cases, both to see how those play out in the prosecutions of the former president, and then how they play out, both in terms of possible prosecutions of future presidents, but also just the conception of presidential power and more broadly.
Yeah, I mean, there's so much about those cases, and I'm sure everyone in the room has followed them closely. I think, my takeaway, I think it's a great example of what Amy said earlier about how this was a John Roberts term. These cases seem to me very much coming from his perspective. Actually, one thing that I kind of couple these decisions with the Rucho versus Common Cause decision a few years ago, where the court said there's no role at all for the Supreme Court in the federal judiciary in policing partisan gerrymandering. And it seems to me this is another example where the court is saying, look, we don't want to be the referee of this. Like, we want the voting and voting by the populace and other political actors to solve these problems, and it's not for us as a court to do. And it seems to me that that's the prevailing view on the court right now. You could have a different view, which is when politics go off the rails, you need the court and the rule of law to step in some fashion to police that and to put boundaries on that. But that is not, I think the view of the court is, it's best for us as an institution if we stay out of it. And I think that the Colorado decision, especially to me, just seems like a very institutionalist decision for the court. As a constitutional law professor, I don't really understand the federalism theory. I mean, Joe Kennedy is going to be on the ballot in some states, but not others. I was reading in the New York Times yesterday that if Vice President Harris is the new Democratic nominee, there's only a certain amount of time before that has to become official for her to get on ballots in places like, I think, California and Arizona, where we sit. And nobody says, and how could that possibly be? And because the Constitution itself gives the states primacy over running elections. And it seemed to me in the Colorado case, where you have a federal issue that is subject to review in the federal Supreme Court, it's not even state law, it's all the more ordinary. But I don't mean to say the court's decision, therefore I find it to be ridiculous, because I think there are enormously weighty institutional counterweights that the court, I think, is balancing against some of those points. The last Trump-related case doesn't have Donald Trump in the title,
Trump
but
adjacent.
we'll use it a little bit through the Trump lens, and we'll use it to say a few words about the court's criminal law docket, because obviously for those of you that practice and decide these cases in the circuit, that's a big part of your work. The last case that had implications for President Trump was called Fisher versus the United States. No relation, just saying. This case arose from the January 6th events at the Capitol, where various prosecutions have been brought, notably for this case, under a provision of the Sarbanes-Oxley Act, passed in the wake of the Enron scandal. That statute prohibits corruptly altering, mutilating, or destroying of documents or other tangible records. And then a final subsection also prohibits, quote, otherwise obstructing, influencing, or impeding any official proceeding. And so the question in this case, for not just for the defendant there, but for implications for lots of other people, including Donald Trump, because that's two of the counts in the Jack Smith indictment that Amy was just discussing in the immunity case, is does this act cover only spoliation and impeding of official records and documents and the like, or just more generally impeding an official proceeding? The court ends up holding 6-3 that the statute is more limited. It covers only spoliation, destruction, obstruction of documents and records, not more generally things like sitting on the courthouse steps and preventing from people going in, or heckling during oral argument, or any number of other things that might impede a official proceeding, and that might seem to be covered on the plain text of the statute, but reading the statute contextually and against the court's growing presumption that federal criminal law should not be construed broadly, to be too sweeping, the court construed it in a narrow manner. And I think that's the notable point of this as we transition maybe out of Donald Trump into criminal law more generally, is one of the themes from this term, both in the Fisher case and in another case called Snyder, where the court held that the federal statute prohibiting officials from accepting gratuities that are in relation to official business they've done dealing with more than $5,000 is limited to gratuities that are actually bribes or kickbacks. That the court is really, this is one of the places on the court's docket, I think, that they're more unified and less ideological than anywhere else, is in this push in the last decade or so to narrowly construe substantive federal criminal law. And it might be the place where textualism is at its weakest ebb in the court. Unless, it depends how you define textualism. Like if you define textualism as literalism, then I think the court really does muscle some federal statutes to be narrower than they would otherwise appear in their ordinary English phraseology. On the other hand, if you take textualism to include canons like the rule of lenity and the presumption that federal law shouldn't be construed if it's ambiguous to intrude on the province of states and other narrowing canons like that, which I think Justice Scalia, for example, did, then I think you understand this as a way where the court is coming together to push back against broad conceptions of federal statutes. So just to give a few other examples that will just sort of drive the point home, another statute, another provision of the Sarbanes-Oxley Act that prevented destroying a tangible object was held in the Yates case several years ago not to include a red snapper. A fish is not a tangible object. We'd say, yeah, it is. But the court said, no, that's outside the spirit of the law. The law would cover too many things. A case called Dubin last year that I handled involved the aggravated identity theft statute. The court construed narrowly so that it wouldn't cover all kinds of sort of misappropriation dealing with internet websites and the like. The Van Buren case, the term before, Kelly. I could go on and on. But I think what's interesting about this area of the court's docket is it seems to me the court is doing criminal law, substantive criminal law, differently from the way it did it when it started my career. When I was a law clerk and I watched arguments in the Supreme Court, and if some justice would say, well, to take the Fisher case as an example, like if the government is right, could this include heckling in a courtroom and like requiring oral argument to stop for 5 minutes while a boisterous obstructionist was removed from the courtroom? I think the Solicitor General's office would have said, oh, we're not going to prosecute a case like that. Like we're not, those fringe cases, we would never do that kind of stuff. Now what the court's approach is look, if you can come up with hypotheticals that fall within the government sweep of the statute, we're not satisfied to leave that to prosecutorial discretion, and we are going to use that as a reason to construe laws more narrowly. And I think I've seen that time and again over the last decade or so, and I think it's kind of a notable trend coming from the court.
I mean, I think that that's sort of there's maybe like an analogy to the Trump immunity case. Is like part of what's going on in that case as well is that the majority would trust the president over the prosecutors, and in this case, it's the same thing. We don't trust the prosecutors not to pursue these anymore.
Right. You had even Justice Alito with that argument saying, don't we have to be afraid of prosecutors maybe misusing this power?
Exactly.
Right? Yeah. All right, you want to do this?
Yeah,
the
we're
next button?
the so-called war on the administrative state, and this is something as the end of the term got closer, and I would talk to my colleagues or talk to people about it, and I would say, these cases really have the potential to be quite significant, but they're really hard to explain to lay people, both in terms to get them to understand what the case is about and to understand the significance. And then fast forward to sort of the afternoon after the Loper-Bright case, the Chevron deference case was decided, and I'm finally finished for the day. I sit down, I pick up my phone, and I look at Twitter, and there's Barbara Streisand tweeting about Chevron deference. So I look at it shows you what I know about whether or not regular people care about administrative law. I'm going to talk sort of focus, I think, because we're running short on time, on the Loper-Bright case, the Chevron deference case, and then talk quickly about two others that sort of the administrative law trifecta this term. But one of the things I wanted to point out was that in each of these cases, one of the court's liberal justices read her dissent from the bench, which, as many of you know, is sort of the sign that they think this is really important. And I think part of this was to draw attention to what they saw as the significance of the decisions. And, Jeff talked about, I think there were sort of two ways to look at what the court has been doing, and this is an example of the court, as far as the liberal justices that were concerned at least, taking on more power at the expense of the federal agencies. So I'm going to start with the Loper-Bright and Relentless cases, which were the cases in which the Supreme Court overturned Chevron. And the Supreme Court had several requests to overturn the Chevron doctrine in recent years. Why in particular they chose these cases, we don't know, but they agreed to take up first the Loper-Bright case out of the DC Circuit, and then it turned out that Justice Jackson had participated in the Loper-Bright case, and so they added the Relentless case out of the First Circuit, sort of fast-tracked it, heard argument in both of them at the same time, but then, as they did in the affirmative action cases last year, just issued one decision with a little footnote that said, by the way, Justice Jackson is recused from this as far as it goes to Loper-Bright. But these cases started as challenges to a rule issued by the National Marine Fisheries Service that required the herring industry to bear the costs of having an observer on board the fishing boats. As they came to the court, the Supreme Court decided it was just going to take up the Chevron deference question. And again, this was a 6-3 decision, again by the Chief Justice. And the Chief Justice said, look, Chevron deference is inconsistent with the Administrative Procedure Act, which says that courts should decide legal questions by applying their own judgment. And he said, this is true even when you're talking about the kind of technical and scientific questions for which you normally think of federal agencies as having particular subject matter expertise. He said Congress expects the federal courts to decide technical statutory questions. We have the benefit of briefing from parties and amici, and so we can get the job done. He said, however, even if we're no longer deferring to an agency's interpretation of the regulation that it administers, courts can still give respect to that interpretation. And then he pushed back against some of the arguments that the federal government and the dissenters made for keeping Chevron. He said stare decisis is not a reason to hold on to Chevron. It had become unworkable because it was so difficult for federal courts to figure out whether or not a statute was ambiguous. And he said no one relied on the Chevron doctrine. The Supreme Court was constantly tinkering with it, and we ourselves have not cited it in 8 years. There was this great moment during the oral argument in the Relentless case. Ramon Martinez was arguing for the challengers, and he was a former clerk to the Chief Justice. And I think the Chief Justice was probably going to this reliance question. And he said something along with like, well, how often does this actually come up? And Ramon Martinez was like, all the time, you know. And then he, suggested that overruling Chevron was not going to lead to all kinds of new cases seeking to open up questions that relied on Chevron in the past. Justice Kagan wrote for the court in this case, wrote for the dissenters in this case. She said, agencies are the ones who have the technical and scientific expertise to do this. And she said, if you think that it was hard for judges to figure out what was ambiguous, and we disagreed about whether or not a statute was ambiguous, and so that overruling Chevron is going to lead to more consistent interpretations of agency interpretations. She said, boy, do you have another thing coming, because now we're just going to be arguing about what respect means. And she said, courts are always going to be able to come up with a reason to overrule cases. You can always find a special justification. So she characterized this as yet another example of this court's resolve to roll back agency authority. Then 2 other cases I'll talk about a little faster to give Jeff room to talk about his cases. One was called SEC versus Jarkizi. It was a challenge to the SEC's enforcement actions. The question was whether or not basically the 7th Amendment right to jury trial bars the SEC and other federal agencies from handling these cases seeking civil damages in-house. Again, by a vote of 6-3, again in a decision by the Chief Justice, the Supreme Court said yes, the 7th Amendment governs here. Justice Sotomayor, in her dissent, pointed out that there are 24 federal agencies that whose statutory setups allow them to seek civil damages, to hold administrative proceedings without a jury trial. Some of them can only use administrative proceedings for enforcement actions. And then finally, on the last day, one of the sort of sleeper cases of the term potentially is a case called Corner Post versus Federal Reserve, involving the statute of limitations to bring an action under the APA. Corner Post was challenging a Federal Reserve regulation governing debit card fees. It's a truck stop in North Dakota. The Federal Reserve issued the regulation in 2011. Corner Post went to court in 2021. The government's argument was the statute of limitations, the 6-year statute of limitations under the APA has already expired. And Corner Post said, well, we didn't come into business until 2018. How are we supposed to challenge it before then? 6-3, this time with Justice Barrett writing, the Supreme Court held that the statute of limitations only begins to run when you're injured by the agency action. So Justice Jackson wrote for the dissenters in this case, again, read from the bench on a case involving the statute of limitations, which you don't hear every day at the court. But she said essentially now with this decision, there's no limitations. If you want to challenge an agency regulation on its face, all you have to do is form a new entity and then go to court within 6 years. So I think she pointed out sort of with the demise of Chevron and in a case like the Mifepristone case, which part of the Mifepristone case, the Fifth Circuit had thrown out on the ground that it was too late to challenge the FDA's initial approval of Mifepristone back in 2000, all kinds of agency regulations could potentially be opened up again.
Right, and obviously a big theme of this term and of the Roberts Court, I think, that we're starting to see come into full bloom is curbing the power of the administrative state in various ways. And to my mind, these decisions are important, but the real question is how far does the court keep going? Because to me, these cases tee up more questions than answers.
Right.
As somebody who's, when I litigate in the court, it's certainly true that Chevron has been dead in the Supreme Court for the better part of a decade, but it wasn't dead in the lower courts.
Right.
And I think that could be...
Which is why they were there.
That could be where the real bite happens. One example as we sit here in the Ninth Circuit is deference to the BIA in immigration cases, for example, is something that you see not just in this circuit, but of course in others. And that could be a place where there's some real bite in the lower courts in a way that the Supreme Court had long since stopped doing that. But this day-to-day work with busy judges and busy dockets, where you now have to really dig in extra hard, I think is going to be interesting to see.
So
how
the
that
Supreme
plays
Court's
out.
docket could be expanding again, but it will also mean that you are likely to be busier.
Yeah, I mean,
in
and
the
the other
short
big
term.
case, I think the other big question that I understand that come out of Lover Bright is the antecedent question, whether Congress has assigned this to an agency to issue regulations of some kind or another. You know, the thing the court really bristled at in Loper Bright was this notion that there's an implicit assumption that any ambiguity is
Right.
thereby ceded to the agency for the agency to decide what to do. I think the court, my understanding of the decision, leaves alone the notion that if Congress expressly assigns power to the agency to issue regulations of a certain kind under certain directives, that the courts actually look to those regulations. So figuring out how that all
Right.
fits together, and then again, how Congress reacts will be super interesting. All right, another big ticket item on the court, and guess what? Another Chief Justice Roberts decision.
There we go.
Is the issue of Second Amendment gun rights and the Rahimi case. So let's touch on that really quickly. That case deals with the provision of federal law that prohibits somebody who has a domestic violence restraining order in place from possessing a firearm. And that was challenged and struck down in the Fifth Circuit on the ground that it violated the Second Amendment right to bear arms as construed by the court in the Heller and Bruin decisions. And of course, in the Bruin decision, the court established this history and tradition test for assessing regulations on firearms. And essentially what the court holds in Rahimi by an 8-to-1 vote with only Justice Thomas dissenting is to apply the history and tradition test, you do not have to find a historical twin. You just have to find an analog. So to put a finer point on it in Rahimi, the court said there's a history all the way back to the founding of restricting firearm possession for those who pose a credible threat to public safety. And that's good enough, even though we do not have a history and tradition in this country of prohibiting people from possessing firearms on basis of domestic violence allegations or findings or the like. So the court said you can draw up a level of abstraction when you ask these history and tradition questions and answer them. And as the Chief Justice said, that way our law is not frozen in amber. As society evolves and domestic violence being an example, people come to appreciate a new form of threat to public safety that can be folded into the history and tradition. So that seemed like a relatively easy case for the court, but as I'm sure many of you know, there are many, many more cases coming, and the court's going to have to decide continually and give more guidance on what is this history and tradition test, and maybe even more so even outside the Second Amendment. Now you're seeing more and more invocations of history and tradition across constitutional law in the court. It's becoming kind of the new currency at the court, and I think this is very much something to watch in coming years. And you have kind of, I think, two different camps that are developing up there even within the conservative wing that are flexing their muscles in these cases. I think you have kind of the Gorsuch-Barrett theory that we look to history and tradition to understand how the framers conceived of these rights they were enshrining in the Constitution. So to use a case I was involved in a few years ago, when the Sixth Amendment guarantees a right to jury trial, and it just simply says that, does the unanimity requirement that exists at common law carry through? And the court says yes, the framers would have understood that as a matter of history to carry through. When they said the jury trial, they would have understood that to carry with it, for example, the unanimity requirement. And that's a way of looking at history really at the time of the founding. Justice Kavanaugh writes separately in Rahimi and says, no, I'm not limiting myself to the founding. I think it's really useful and helpful to look at tradition as it carries on quite far past the founding, as developed in state common law and maybe other just legislation at the state and local level or even the federal level. And there I can also draw lessons of how the Constitution has been, as Will Bode puts it, liquidized for everybody. So that we've come to understand this is the boundaries, and then if we have this accepted understanding for some number of decades and depart from it, that itself poses a constitutional problem. And I don't think the court has come to ground on this. And so I think it's just one thing that we're all going to be thinking deeply about. Having done this, I have not been involved well, I actually have been involved in one Second Amendment case, but not these. But having done them in other areas of criminal law where the court looks to history, it's a real challenge. I mean, I think it's for all of us who act as lawyers, it's a lot more time and energy to do this kind of research and present it to courts. And I think for courts, it's a lot more effort to really, look carefully and scrutinize this. I mean, Justice Scalia used to criticize legislative history for sort of looking out in a crowd and finding your friends. Well, try 50 states worth of common law over 100 years. You can find a lot of stuff. And so to really, truly synthesize it and make sense of it, and where are those state courts really sort of doing that work against the backdrop of maybe constitutional postulates or structural features of our federal system, and where are they just doing their own thing as a matter of state law, I think is a really tricky thing to look into. So I'm a believer this stuff is useful, but I think it's also subject to to sort of carelessness and manipulation as well. So I think we're all going to have to kind of dig into this. I don't know if you have any thoughts on that.
Well, I mean, and as Jeff suggested, I think it's coming back to the Supreme Court, almost certainly coming back to the Supreme Court quite soon in some of these other Second Amendment cases. When the Supreme Court left for its summer recess, before it left, it sort of sent us several different Second Amendment cases back to the lower courts, including at least one that the government had wanted the Supreme Court to take up in the wake of the decision in Rahimi involving, the Rahimi was based on the idea that you could restrict the gun rights of people who posed a danger to society. Well, what about people who are nonviolent felons? Someone who committed food stamp fraud or Medicaid fraud or something like that. And so those are going back, and now the courts are going to have to grapple again. They've gotten a little bit more, either clarification or guidance, whatever you want to call the Supreme Court's decision in Rahimi about what to do next. But it's, I think it's still going to be a challenge, both in terms of exactly what the court meant in Rahimi and then the historical analysis itself.
So I'm going to mention one last topic, and then we're going to take questions. But I think it's important to just hit off one other substantive area of maybe particular interest in this circuit, which is social media and tech and the First Amendment implications. And then I think it raises another interesting question to watch as the court continues to evolve and decide cases. And so this most notably was the Moody versus Net Choice case, which arose from two state laws from Florida and Texas that restricted Facebook and other YouTube and big social media platforms in their ability to do what they call content moderation. But what Texas and Florida wanted to do with their laws was make sure that content moderation doesn't become a vehicle for viewpoint discrimination. And the particular concern in those states that conservative viewpoints are being suppressed relative to, or at least shoved down the algorithm relative to other perspectives. And so that case goes up to the court. And the court established, I think, a few important principles in that case, and I'll share one higher level reaction. So one is the court holds, and this is actually not a Chief Justice Roberts opinion, it's Justice Kagan, the circuit justice here, wrote this decision for the court, establishing three, I think, important principles as these cases come to you or you handle them as lawyers. One is that social media companies like Facebook and YouTube are publishers and editors for purposes of the First Amendment, just like a publisher and editor of a newspaper or a magazine or other First Amendment media content. Second, it doesn't matter for purposes of the First Amendment analysis when regulation is at issue, whether whether the content itself is incredibly widely varied or how heavily it's edited. It is enough that there's some curation, that there are some limitations, even if at the outer far edges. That is enough to bring these platforms and businesses under the banner of the First Amendment. The court analogized not just to newspapers and the like, but also to the parade that was the source of the Irish-American parade case at Hurley, where the court held that even though there's a million messages in a parade, the First Amendment still protects the parade organizer's ability to decide who's in and who's out. And then finally, this court said, reiterating traditional First Amendment case law, that the goal of regulating private speech for purposes of achieving greater balance and greater diversity or greater neutrality is itself an illegitimate objective. Even though that sounds in some ways like what we ought to be aiming for by way of communication in a free society, that's for the private sector to work out, not for the government to enforce. And private actors have their own voice. Private editors have their own right to choose what goes on and off their platforms. And so for that reason, at least in some applications, the Florida and Texas laws are unconstitutional. And the last thing I think is really noteworthy about these cases is that it's interesting to me that what the court did is they said, look, this is just the modern First Amendment as applied to a new form of media. But all the traditional principles, at least to this point, have kind of been carried forward, which to me is a dichotomy from, I'll just use an example of cases I've been involved in, the Riley and Carpenter cases, where the court said digital privacy as a matter of Fourth Amendment law is itself qualitatively different, and the old rules for the analog universe don't carry over to the digital world. But when it comes to the First Amendment, the court seems to have gone the other direction. They said, at least for now, the old rules do carry forward. And whatever new threats or dangers social media pose relative to newspapers, magazines, other forms of speech, the First Amendment so far is not treating this new media differently.
The other thing, I mean, the justices seem much more confident with technology these days than they have in the past. I remember being at your argument in Riley and some of the other arguments involving cell phones, and they perhaps were not as technology savvy. I mean, I think Justice Kagan last term in another one of the cases, the Gonzalez versus the Tomna versus Twitter cases involving Section 230, said, we're not exactly the 9 greatest experts on the internet, but they just seem more confident than they have in the past.
Absolutely.
All right, questions? This feels like the Oscars or
exactly,
something.
And the winner is? Okay, I think we did that one. Let's see. So actually, I'll ask this question, and I'll keep flipping through, and I'll let you talk first. So with a focus on history and tradition in the Second Amendment context, what is the future of the tiers of scrutiny in other areas of constitutional law, and how do you see that?
You are the constitutional
You want me to do
law
that? Okay,
professor here.
then I'll hand them to you.
Yes, exactly.
I think that's a great question, because I think what's really driving this history and tradition test in the Second Amendment context is a feeling on the court that it's better than the tiers of scrutiny, and particularly the means-ends balancing, where you ask whether it's a compelling interest of some level against, and whether it's narrowly tailored to achieve that interest. And I think there's a feeling among the proponents of the history and tradition test that it does a better job of constraining judicial discretion and judicial policy making than traditional means-ends scrutiny. So I do think there's very much going to be a push to move history and tradition out into other areas of constitutional law. And I do think the court is going to become more and more wary of the traditional means-ends scrutiny. Our clinic had a First Amendment case a couple years ago dealing with the power of a legislature to censure one of its members. And interestingly, the court decided that First Amendment case based on history and tradition, not based on the tiers of scrutiny, for example. In the equal protection context, I feel like the court is a little more entrenched in means-ends scrutiny. But I very much see a movement on the court to make this the dominant way of approaching constitutional law, also in the criminal law areas. I've mentioned the criminal procedure amendments. So I think the court is going to be balancing its desire to have that be a more dominant test and a more dominant way to approach constitutional law against just regular stare decisis, which in so many areas sets up a very precise tiered scrutiny test. And so, whether the court will accept that as a matter of stare decisis in various other areas of constitutional law, I think is the big question.
Okay. So I'm going to take the next one because I think it's an interesting question.
Okay.
It used to be said that big terms are followed by quiet terms, and now it feels like big terms only, which I totally agree with. Any predictions for October term 2024? So far, then the court really, until the very end of June, didn't even have much on its docket for the fall. They usually grant all of their cases for the fall by the time they go away to take their summer recess. And right now, there are certainly some really interesting cases on the docket for the fall, but not like of the super high profile kind that we have been discussing today. So I think probably the highest profile cases on the docket so far are United States versus Scarametti, which is the challenge to Tennessee's ban on puberty blockers and hormone therapy for transgender minors. There is Free Speech versus Paxton, another case out of the Fifth Circuit, which is the challenge to a Texas law that requires pornography sites to verify the ages of their online users. And then there is the relatively rare death penalty case, Glossop versus Oklahoma. The interesting part about this case, among other things, is that the Oklahoma Attorney General has joined the inmate in seeking Supreme Court review and in arguing for his conviction and his death sentence to be set aside. So those are three. There's also a case involving the Biden administration's efforts to regulate ghost guns, Garland versus Vanderstock, I think it's called. However, like a lot of the cases that we talked about were argued in the second half of the term, and those cases weren't granted at this time last year. So I would say right now it certainly looks like a slightly quieter term than the past couple of terms, but also stay tuned.
Right. I think maybe the court might in some ways prefer the up and down of years past, but it doesn't seem to happen. And I think the other thing that's noteworthy about the upcoming term, of course, is that we have an election coming up, right? So that brings us back to the top of the hour where we talked about the shadow docket. And many in the Supreme Court practice world were commenting that the court was granting cert at an even slower pace for next term than it had even in these record low previous two terms. And one potential explanation for that is the court is trying to keep room on its docket in the fall for whatever form of election case or another comes its way. And who knows whether it will or not. But it's probably safe to say there's going to be litigation. Whether it reaches the court and whether the court gets involved,
when it reaches the court,
million other questions.
Right.
But I think that's the other potential big thing looming out there from the court's perspective.
Of course.
So another question is, in terms of the court's criminal docket, is the court granting cert on the issues that most need resolving? And what areas of criminal law should the court be weighing in on more, in my humble opinion?
All of them.
So the court has been very active, I think, in substantive criminal law, as I described earlier, and I mean that both in terms of just whether something is a crime and in terms of statutes like ACCA and other sentence enhancement type provisions. There's a case this term I was involved in called Erlinger, where the court kind of dealt with ACCA as the Sixth Amendment Apprendi doctrine applied to that statute. So sentencing and substantive criminal law, the court seems, I think, pretty active and quite responsive. It's one area that I think that, as I said, they can agree and they can also grant in those cases. Maybe those two things are related. You can grant in those cases. The two areas that I've seen that I would flag, and I'd be super curious what those of you in the room who experience this in your own lives in various ways would say, but two areas I've seen that I think I would love to see the court step into a little more, one a little more aggressively and one where it's just not stepped in at all. The first is forfeiture. Criminal forfeiture is an area that is, it is a big feature of a lot of criminal litigation. The forfeiture statutes are kind of broadly written and complicated and hard to piece together. And I've seen several cases over the past 5 to 10 years where the court in a case called Honeycutt curbed sort of one of the government's big ways of procuring forfeiture, but there are many other open questions and various confusion about how broad the government's forfeiture power is, which is a very big deal in criminal cases for defendants especially. The other area I think I would love to see the court step into are waivers. As you all know, 95+% of criminal cases are resolved by plea bargain, not by trial. And more, those plea bargains carry a waiver of one form or another of a limited or full waiver of appellate rights. And I think this varies quite a bit district to district and circuit to circuit. But I had a case on this a few years ago, and it was one of those places where when I dug into the law and did a petition for the Supreme Court, it was almost like everything was too confused Sometimes it's like great to go to the Supreme Court and say there's 3 circuits to do this and 3 circuits to do the other thing, and there's a neat little circuit split to solve. Then there's these issues where it's like the 4th Circuit thinks it's following the 5th Circuit, the 5th Circuit thinks it doesn't do what the 4th Circuit does, the 3rd Circuit uses the same standard as the 9th Circuit, but it doesn't mean it, but it doesn't apply it the same way, and everybody's doing completely different things and saying same words to mean different things. And in the waiver area, whether waivers of appellate rights preclude things like challenges to an allegedly illegal sentence, or even something that has later found by Supreme Court decision or a circuit level decision not to be a crime at all, or other irregularities like failure to disclose under Brady. What kinds of things can open appellate waivers? For whatever reason, the court has just left that alone, and I think it's a very big lurking issue. I'll just say for my 2 cents, but I'd love to hear more from you all. Okay, so we have...
Wait, a few minutes, okay.
Yeah, go ahead. There's a question about the Sackler case, the Harrington versus Purdue Pharma. Are you up on that case?
I mean,
do you want to say anything about it?
I can say a little bit about it. I mean, that was an interesting one in the sense that it was not one that divided. It was 5-4, did not divide on ideological grounds. This was whether or not to put the bankruptcy plan for Purdue Pharma on hold. It was an $11 billion bankruptcy plan. The Sackler family I think maybe it was 11, but the Sackler family had taken $11 billion in pre-tax income out of the company in the years running up to the lawsuits over OxyContin. And then as part of the bankruptcy plan, they agreed to put, I think, about $6 billion in the post-tax money back into the plan. And in return, they would get releases from liability, even though they were not the ones who were declaring bankruptcy. The oral argument in that case was really fascinating because the justices were really just kind of trying to work it out in real time in terms of what would happen with or without the bankruptcy plan. And they divided 5-4, again, not on ideological grounds. I think Justice Kavanaugh wrote for the dissenters in that case, and I think Justice Kagan joined him. And I think now is the question. I've been trying to follow the news stories about sort of what's going to happen to this plan going forward in terms of now the lawsuits are back against the Purdue Pharma and against the Sacklers. And I think the justices who voted to put the plan on hold were hoping, this is not going to stop the plan from going forward. Maybe the Sacklers will kick in some more money. So it was really sort of a fascinating thing to watch. I mean, the Supreme Court does not get a lot of really high-profile bankruptcy cases, and so this was really an interesting one to watch.
Yeah, I mean, bankruptcy is one of those areas that's such a big deal, and I think sometimes people in sort of practice corporate law and the like, things, wish the court would do more in some of the business. There's a lot of talk in recent years about the court being either business-friendly or just invested in the business docket, but I don't know that that's been true as much lately. So when I talk to people who practice in some of the big firms and do more corporate commercial type work, I think they wish the court would do more. So, yeah. But they still wish that, I don't know. But
then there's another question about Rahimi and Bruen and the Chief Justice's law is not trapped in amber standard, which, I really sort of wrote something that I think sort of sings. It's just such a wonderful metaphor and so easy to remember. And there was a lot of discussion leading up to the decision in Rahimi about exactly how it was going to play out. And I think, we talked a little bit about it, but what exactly was the court doing in Rahimi? Was it clarifying and providing more guidance, or was it effectively sort of rewriting Bruen because it realized once lower courts started applying Bruen that it wasn't really working out the way that they had hoped. And so the fact that Justice Thomas dissented suggests that maybe they were not clarifying and guiding as much as they were rewriting.
Yeah. Well, I think we probably want to keep the trains on time.
Oh, there we go.
And I just want to conclude by saying it's just such a privilege to be part of this event.
Yes.
So thank you so much.
Thank you so much for having us.
Thank you.